Good morning, everyone. My name is Steve Alston, and I am with the Virginia Community Criminal Justice Association. And I wanted to welcome you today to our webinar entitled Virginia's Pretrial Justice System, Fair and Equitable, or Time for a Change. We are really excited to be bringing you this webinar, and it is actually a two-part webinar. But first, let me tell you a little bit about our association. The Virginia Community Criminal Justice Association, VCCJA, is a professional association that advocates for the best practices in pretrial services and probation field. And we have about 500 members, and we're based here in Virginia. Today's webinar has been organized with the help of the Miller Center at the University of Virginia, so we would like to thank them for their assistance today. So today, we're going to have a great conversation, I think, and it's actually going to be a two-part conversation. The first session's being today, and the second one will be in October, on October 19th. We wanted to talk about what we want to achieve over the course of these two webinars. Today, we're going to talk on the education of this important topic of fairness and equity in the criminal justice system, with a focus very specific on the pretrial justice end of things. We hope that we're going to have a robust discussion today, and I know we will because we have an excellent panel today that's going to hopefully impact policy and provide an opportunity to improve how the pretrial justice system is operating in Virginia. Today's panel are advocates that have worked in the field for many years, and they've been very successful in the work that they've been doing. And I think you'll find that their experiences and their breadth of knowledge is really quite incredible, and you're going to really enjoy hearing the things that they have to say. Again, thanks to the Miller Center. Particularly, I want to say thank you to Howard Witt, who's behind the scenes at the Miller Center at the University of Virginia. They have partnered with us and provided the technical expertise and made today possible. Otherwise, it would have been very difficult for our association to do this, so thank you to them again. I want to remind the participants today that we do have closed captioning available to you. All you need to do is to go to the link that I sent yesterday afternoon and open that up in a separate window if you'd like to use the closed captioning feature. Today's webinar will be very interactive. We'll be taking questions from the audience, and we will also be asking that you use the question and answer feature at the bottom of the Zoom screen to send us your questions. The chat feature or the raise hand feature is not being used, so please ask your questions through the Q&A function, and the panel will answer as many questions as we can today. We do encourage your participation because that will make for a more robust conversation. I did want to say too that we had about 300 people registered today, and so we're hoping that we'll have at least 200 to 250 people on today. And I also wanted to note that should you know people who wanted to watch and couldn't today, we are going to be posting it on our website, the VCCJ website afterwards, and we'll be sending out the link to all the registered participants if you want to do this again later, or you want to pass it on to other people. Today, we're going to really discuss on several areas. Most importantly, fairness and equity in the pretrial justice system, as I mentioned earlier. Again, we want to focus on this part of the criminal justice system. You know, there's been much conversation across the country in the last several years on criminal justice reform. We often don't hear quite as much conversation around the pretrial stage of the criminal justice system. So that's why today's topic will be focused on that. We want to focus on pretrial detention and the impacts that it has on individuals, on families. We want to talk about bail systems and its impact on individuals, as well as the ripple effects that the pretrial justice system has on families and our social systems. Our panelists today, as I said earlier, are very dynamic advocates who have been working for change, and they've been very successful in their efforts. I want to thank them again for their expertise today, as this has been such an important topic in the last few years. Here in Virginia, and I do want to note, we do have participation not just in the Commonwealth of Virginia, but across the country. But the topic is very, very relevant across the country. It's being discussed in many states, and there's been lots of bail reform and other things that have happened to change the pretrial justice system. And so those are some of the topics we want to cover today. But this ripple effect of the pretrial justice system really does have quite an impact on families and social systems. So in addition to all the things I already mentioned, we want to talk about how this really impacts our community and our country. And so I'm going to first move to introduce our panel as well. We do have 3 people joining us today. We're going to do kind of a keynote presentation, and then we're going to have a panel discussion. So our 3 panelists that are joining us today are, and I'm going to introduce them and give a little bit of their bios. Christopher Rashad Green, who is the lead organizer for the New Virginia Minorities Criminal Justice Campaign in Richmond, Virginia, and founder of a new re-entry initiative, Freedom Unlimited Incorporated, in the Richmond area. He is a formerly incarcerated activist and advocate who uses his gifts of discernment and empathy to distinctly articulate his emotional experiences in the criminal system. He was instrumental in establishing Virginia's the New Virginia Minorities Court Watch program, and so we're going to be hearing a lot about that, and because that's been some real important work that's been watching what's going on across the state. Alec Karakatsanis is the founder and executive director of Civil Rights Corps. Before founding Civil Rights Corps, Alex was a civil rights lawyer and public defender with the Special Litigation Division of the Public Defender Service for the District of Columbia, a federal public defender in Alabama, representing impoverished individuals accused of federal crimes, and co-founder of the nonprofit Equal Justice Under the Law. Alex has received awards for his role in bringing constitutional civil rights cases to challenge the American money bail system. He has authored numerous books and publications and is interested in ending human caging, surveillance, the death penalty, immigration laws, and inequality. And Alex has much that he will be saying about some of the great work that he's done and some of the legal challenges that he's been successful across the country. Kim Rolla is the interim legal director of Legal Aid Justice Center Civil Rights and Racial Justice Program. They joined LAJC as the Lewis F. Powell Fellow in 2013. They originally focused on housing law, providing both individual legal representation and legal support to tenant organizations. In 2017, Kim transitioned to the Civil Rights and Racial Justice Program, where they now develop campaigns to combat the criminalization of the poor, people of color, and far too many Virginians. Kim was co-founder of the National Lawyers Guild Central Virginia chapter. They also serve on the advisory council for the Charlottesville Public Housing Association of Residents and on the board of the Virginia Equity Bar Association, the LGBTQ Affinity Bar. So, just to clarify, Christopher Rashad Green is with New Virginia Majority. Sorry, I think I might have said that wrong. So thank you for the clarification. And so I'm going to pivot to Alex to start the conversation and talk about some of the good work that he's been doing across the country. Alec?
Thank you so much, Stephen. Can you hear me okay? Wonderful. It's an honor to be with you all in conversation. A big fan of New Virginia Majority and all of the work that you all have been doing on the ground for years. And it's a privilege to be in conversation with you. And also the Legal Aid Justice Center, who we've whose work we're familiar with over the years and who've been inspiring and leading the fight against many of the injustices in our criminal legal system, including the suspension of driver's licenses, the combination of immigration and criminal punishment bureaucracies, and many of the other things that I hope we can talk about today in terms of how they intersect actually with the pretrial system. Let me take a step back first and just talk a little bit about my own journey into this particular area. I was a public defender for 4.5 years, and in that position represented numerous people, human beings accused of crimes who were detained prior to trial. And I saw firsthand the devastating effects of being put in a cage prior to trial. And when I left the public defender's office and got a little grant from Harvard Law School to start challenging these systems around the country, the first thing I did was start to think about how might we challenge the pretrial system, because what happens to someone after they're arrested in the pretrial period is the most important decision that has the biggest impact on the rest of their case. And so on January 15th, 2015, after a lot of hard work thinking through some of the intellectual arguments and legal arguments and moral arguments that one might make, we brought the first challenge to the American money bail system under the due process and equal protection clauses in a generation since the rise of mass incarceration. And the woman who brought that case was named Christy Dawn Varden. And I met Christy in a jail cell in Clanton, Alabama, one morning in January. And Christy had been arrested for shoplifting from a Walmart. And she couldn't afford the $500 on the misdemeanor charges that she was charged with. And so she was separated from her kids, and she didn't know where her two kids were in a cage. And Christy was really distraught, and she was screaming and crying the night of her arrest and the next day, and the jail guards got fed up with her. And so they took Christy into a little hallway that they keep away from the security cameras, where they have a little chair. And on that chair, they keep restraints. And they strapped her into the restraint chair, and they tased her body over and over and over again until she could no longer scream. And she could no longer ask for her kids. She could no longer ask for her parents. She just was unable to speak. And the next morning when I met her, I took photographs of all the taser wounds on her body. I open with that story because I think as a profession, whether it's defense attorneys like myself, or prosecutors or judges or pretrial services officers and probation officers, all of us who are involved in what I call the punishment bureaucracy, I think are guilty of not appreciating the extraordinary brutality that is inherent in putting a human being in a cage, and of creating a bureaucracy that processes 11 million human beings every single year from their schools and homes and churches and jobs and communities and families into a government-run bureaucracy that treats them inhumanely and with incredible cruelty and indifference to their pain. Speaking, only for myself, in the 4.5 years I was a public defender, neither I nor, to my knowledge, any other attorney from my office filed a single appeal of a pretrial detention decision. And I think we have to sit with that. What does it mean that the people who were supposed to be advocating for our clients were so normalized to the concept of pretrial detention that we didn't even ask the appellate courts to intervene in it? It was seen as a daily, everyday aspect of representing people charged with crimes. When I first told people, I remember I went to a meeting at the DOJ in Washington, and then to the White House when we first brought these cases, and I started telling people we were going to challenge the American money bail system. People laughed at us. And they said, well, we use the money bail system in 3,000 jurisdictions. There are 450,000 people in jail cells in this country right now, just because they can't pay money bail. Never going to win those cases. And, our intention actually was not ever to win those cases, although we ended up winning most of these cases. And I'll talk a little bit about why. Our intention was to tell a different story about what the criminal punishment system was doing to people and why, and to force people to confront a very simple question. If our legal system is willing to put a human being in a cage solely because she doesn't have enough money to pay, what else is it willing to do? What confidence can we have in all of the rest of what this system is doing? Is it making us safer? Are the things that the system is doing designed to help communities flourish? Or do they have other goals in mind? What is driving the system? In every single city, county, and state in this country, for example, the pretrial system disproportionately cages and surveils and supervises Black people. Is that a coincidence? Or is the system doing something that we're not talking about, right? What are its actual functions and roles? And so we brought these cases, and we then partnered with community organizers all over the country. In the first 10 months of 2015, we brought 12 challenges in 12 different cities to the money bail systems, all the way from New Orleans, Louisiana, to San Francisco, California, to Ferguson, Missouri, Chicago, Illinois. And over the years, we've been litigating these issues in partnership with local organizers who are trying to build power around changing the way the system functions, and also with artists and musicians and activists and faith leaders and others in the community who can each, from their own perspective, particularly when highlighting the stories and experiences of people who've been directly impacted by the system, who can change the way all of us think about the system and who can resensitize us to cruelty that should have shocked us to the core. So why did I start with Christy's story? Well, I think it reflects a few really important things. Number one, most of us have no conception of how cruel prisons and jails are. In all of our cases around the country, we go into jails all over the country, and the things that we see are shocking. We just got a case in Tennessee. We're working on a bail case, and in that jail, they keep people naked and shackled to door handles and benches. They keep people shackled to their own wheelchairs inside the jail. People are overflowing. In every single jail that I went to in 2015, I saw feces and blood and mucus and mold and urine on the floors and the walls. Saw people sleeping on top of each other next to toilets. Even in the places that are thought of as more progressive cities, what's happening in their local jails is an abomination. And it's not just things like squalor and it's also just the things that we all take for granted in life. It's the separation of families. A couple of years ago, people got very upset at the Trump administration for separating families at the border, but you have to understand that there are 3,163 local jails in this country where we separate families every single day because someone is accused of a crime pre-trial. Most of the time because they can't pay money bail. This is child and family separation, and most of those jails have gotten rid of the right to contact visits, to hug your mother or your father or your child, and instead they've replaced them with for-profit video and telephone systems. And in most jails that we've investigated around the country, they pay a cut of the video calls and phone revenue to the sheriff as an incentive to get rid of in-person visits, because they know that people are going to use the video and the phone calls more if they get rid of in-person visits. That's the system that we've allowed. And when we order someone into jail pre-trial, we're not only sending them to a place where 3.3% of jail inmates report having been sexually assaulted in their last trip to the jail, or physical assault, or family separation, or squalor. We're sending them to places where they're unlikely to get fresh air or sunlight or exercise, the things that we all take for granted every single day that make us live full human lives. I think it's absolutely essential that we recognize the stakes of the pretrial bail decision. And so we brought these cases not only to win legal arguments about what the Constitution says about what has to happen at a bail hearing, but to change the narrative and the conversation about what it means for a human being to be taken away from their family and put into a cage prior to trial. I just want to make one note, because of the situation we find ourselves in now with the COVID pandemic. There are about 300,000 human beings in solitary confinement right now across the country. And I encourage you all to do as much reading and learning as you can about what that actually means, because it's a horrific, torturous practice. So we presented this kind of information to the federal courts all across the country, and we started winning these cases. And the federal courts started to say, wait a second, it's not consistent with the federal Constitution, with due process and equal protection, to keep people in a jail cell just because they can't make a monetary payment. And so the first fundamental principle of the winning in all of our cases is that the Constitution grants all human beings a fundamental right to liberty, to bodily liberty prior to trial. And what does it mean when the Supreme Court calls a right fundamental? Well, it means that right can only be deprived if the government has extremely good reasons and if the government provides extremely robust process. So from my experience meeting with prosecutors and public defenders and judges in Virginia, this right is routinely violated every single day throughout Virginia. Judges are setting monetary bond and otherwise accomplishing pretrial detention without a rigorous inquiry into whether it is absolutely necessary as a last resort. What does that mean? What are the federal courts and state courts around the country saying? Well, they're saying if you want to put someone in jail prior to trial, whether you call it an order of pretrial detention or whether you set a money bond that is unaffordable, because those two things are the same thing, right? If I tell you I'm going to release you, but then condition your release on something that's impossible, like running a 1-minute mile or giving me a unicorn or paying me $1 million, what I've actually done is detained you. So the first thing the courts are saying is an unattainable money bond is the same thing from a legal perspective as an order of detention. And the second thing they're saying is an order of detention requires the court to make a very simple finding. And that finding is this person such a danger to the community or a risk of flight that there's no other condition or combination of conditions short of taking them away from their families and confining them in this cage that could reasonably protect the community or reasonably ensure their appearance in court. That's a very high standard because there's lots of alternatives that we have to caging someone. So we have to force courts to make that very difficult alternative. And no longer should we be having bail hearings that last 5 seconds, 10 seconds, 30 seconds, or a minute. We've been working with public defenders and pretrial services officers and others and judges across the country to make people understand that a bail hearing that determines whether someone is taken away from their family or their children, their house or their job for months, this hearing should last 30 minutes, 40 minutes, an hour, 2 hours, all the time that is necessary to collect all of the information, to have family members as a witness, to have employers as a witness, to put on evidence, to confront evidence that the prosecution might be offering. And when we talk to prosecutors, we have been asking the question, given that the research shows that just jailing someone for even 2 or 3 days after their arrest makes them more likely to commit crime in the future, do you have a good argument for why caging this person right now is absolutely necessary for some kind of imminent public safety risk? And if you do not, you as a prosecutor have an obligation to ensure that they're released prior to trial. The third thing that the courts have been saying is to make that decision about what's necessary prior to trial, the court has to have a robust hearing. There has to be a lawyer present. There has to be evidence and witnesses. You have to have an opportunity to confront witnesses. And the judge must make a finding by clear and convincing evidence. So that's the legal framework. I won't spend more time on that unless people are interested in the question and answer period. The two additional points I really want to make are the decision of that pretrial stage has really important consequences for later in the case. If you're detained prior to trial, you're much more likely to be convicted. You're much more likely to get a prison sentence, jail sentence. You're much more likely to get a longer sentence, and you're much more likely to have collateral consequences even after the whole case is theoretically over. So it's very important. And the second thing is we're in it now where through the organizing and advocacy of many people around the country, through some of the litigation wins that we've had, we have reached this moment of so-called bail reform. And everyone is talking about pretrial reform and bail reform. And I think it's a very, very dangerous time because we are at a time when the same interests that created the assembly line money bail system are still in power and determining what replaces it. And make no mistake, when large bureaucracies are in a position to reform themselves, they're going to try to do the same exact things but using different labels. What do I mean by that? We did federal pretrial bail reform in 1984. There was a huge uproar about the injustice of money bail and poor people being detained because they couldn't pay. And so the federal government, with the leadership of a number of judges and prosecutors and others, they got rid of the money bail system. On the day they got rid of that money bail system, the pretrial detention rate in federal courts around the country was 24%. It was a big problem. A quarter of all people who were presumed innocent were detained just because they were poor. But today, as I'm speaking to you, 36 years after bail reform, the pretrial detention rate is 72.4%. So we got rid of wealth-based money bail, but we tripled pretrial detention. And that was because they replaced money bail with a system of preventive pretrial detention. And the same assembly line that relied on the money bail system to churn cases through it and to coerce quick guilty pleas was still in place. And in the rise of mass incarceration, it became more and more important for courts managing their dockets to coerce people into pleading guilty. This was one of the most important findings of Chief Judge Lee Rosenthal, a Republican-appointed federal judge in Houston, the Chief Judge of the Southern District of Texas, who held an 8-day unprecedented federal trial about the money bail system. And Chief Judge Rosenthal found, when looking at all of the evidence from experts across the country, many really interesting, important things, including that if you were detained prior to trial, you were much more likely to plead guilty, so much so that 84% of the people in this hundreds of thousands of person data set that we studied in Houston, 84% of them pled guilty in a median of a few days if they were stuck in jail. If they were released, 51% of them never got convicted at all. So you have this system where if you're too poor to pay a few $100s to get out of jail, you're overwhelmingly likely to plead guilty and get convicted. Where if you have just a few $100s of your family to get out of jail and fight your case, you're more likely than not to have all the charges go away or to be acquitted. This is a multi-tiered system of so-called justice that I have a big fear the bail reformed jurisdictions will simply try to reproduce that same assembly line bureaucracy, because one of the fundamental principles, and this is one of the things that I explore in much more detail in my book, Usual Cruelty, which I recommend to you all if you're interested. And in Usual Cruelty, I try to describe how one of the fundamental laws of this area is if you make the bureaucracy bigger and more powerful, it will try as hard as possible to keep reproducing itself, to maintain that size. And so when we're thinking about bail reform, we can't just be letting the system replace wealth-based detention with preventive pretrial detention. And a second thing we have to be very careful of is all of the financial interests that are behind the money bail industry. They're smart. They see the writing on the wall. They see bail reform. So what are they doing? All of the investors are switching their business models. Instead of being the person that sells you the bail bond, they now want to be the person that sells you the electronic monitoring device for your surveillance, the drug testing, the for-profit supervision. There's actually much more money to be made in that field. And so that's why we're seeing Geo Group, the largest, one of the largest two private prison conglomerates, has now purchased the largest electronic monitoring device company. Securus and GTL, the two largest prison telecom companies that are gouging people and their families on prison telecom, they have also purchased electronic monitoring companies. There's two Israeli defense contractors that are the fourth and fifth largest electronic monitoring companies. One of them just signed a multi-million-dollar contract with the pretrial services apparatus in San Francisco, for example. All over the country, we're seeing the private interests that used to profit off the bail bond changing the facade on their business. And now they're going to be selling you EM and GPS and drug testing monitors and cell phone apps for tracking you. And so what we have to understand is no reform that doesn't reduce and shrink the size of this whole bureaucracy is actually going to lead to change, because the same institutional interests that want the assembly line criminal punishment bureaucracy moving, and the same profit financial interests that want to make money off of the criminal punishment bureaucracy and the poor people and disproportionately Black people who are thrust into that system, they're going to just change their business models and their way of doing things. And so if I had to leave you for our discussion with one really important point, it's think about how if you don't build power to fundamentally change like who is using these systems for what purposes, these systems have a tendency to reproduce the same mechanisms of oppression with a different label. So I'll just stop there and we can open it up for the rest of you all to join the discussion. Thank you so much for having me.
Great discussion, Alex. Thank you for that conversation and really good points about reform and how, you know, if we don't change our overall culture, it really may not be it could be bad if we don't really do it the right way and work to change the culture. So that's really, really important point. And thank you for giving us a lot to think about. I want to remind the participants on the webinar about the question and answer feature, and make sure that you start sending us questions when you can. I'm going to pivot over to Christopher and talk a little bit about his work with Virginia's new majority about the initiatives that they've been working on regarding pretrial justice. So Christopher, you all have been doing a lot of work in Virginia in particular, and your work down in the Richmond metro area, and I think probably beyond that, has been doing court watch. And that means you've been going and sitting and watching and actually observing how a day works in court and what happens and what happens with the judges and what happens with the prosecutors, who's there at those hearings. So why don't you tell us a little bit about that work and what you have discovered?
Okay, thank you. Thank you. I'm honored to be on this panel. Thank you, Alec. You hit it right on the nose. You actually were telling my story, because as I was introduced, I'm a formerly incarcerated individual. Over a 40-year period, I experienced 15 years of incarceration. And I always share with folks that the pretrial detention, pretrial system, and the jails are some of the worst places to be. We think of prisons But jail and being in pretrial is probably some of the worst experiences I've ever had. In all my travels, I've only seen one person actually murdered, and that was in a jail. He was assaulted, and his injuries ultimately led to his death. So yes, it's a very traumatic place to experience. And I thank you, Alec. You couldn't have told it any more better. We can go into the impacts of how they affect individuals, but we can go on and on about what's actually going on in our systems. But ultimately, I want to thank everybody on the panel, and I want to thank New Virginia Majority for bringing me on and allowing me to share my story and to actually help mobilize individuals in Richmond for our Court Watch program. New Virginia Majority implemented it in 2018, and it was basically a community-led program. And our ultimate goal was always transparency and accountability, because we see that as one of the main goals that we have to force, amongst those entities, amongst our court system and our jail systems. There has to be transparency and accountability. So when we implemented the Court Watch program, as I said, I mobilized community members. This was a program, and I must share that we were very successful. In over a year's time, we looked at nearly 1,000 cases. In our Court Watch initiative, we would go and observe the pretrial process. That's what we focused on, because we were looking at denial of bails. And so when we implemented the program, and correct me if I'm wrong, this is one of my colleagues on the call, Kim, prior to when we implemented it, we've seen in Virginia, anywhere between 20 and 30,000 folks are incarcerated on any given day in Virginia. And we only have about 30,000 folks in the prison system, but you're looking at between 15 and 30,000 daily being incarcerated in local and regional jails. And over 60% of them are in there for misdemeanor crimes. And that's astounding. So that's one of the things we saw. And our demands when we went in were basically would look at the lack of legal representation that folks get, as Alex touched on. We've seen that 80%, and let me backtrack. We looked at we went to Chesterfield County District Court, that's in Virginia, in Chesterfield County. Many folks call it arrest-a-field, because it's very restrictive, and their arrest rates and the way they stop and frisk and the profiling for it has been known for years. So many folks in the community call it arrest-a-field. So we went in and we looked, and we found that 80% of folks who are go before arraignment judges and looking for bails are indigent. And that's across the board. I've talked to advocates all across the country, and that's basically a steady number. 80% of folks can't afford an attorney. We looked at lack of representation. We looked at the lack of the denial of bonds. We looked at how in the district, the demographics looked at over 60% of the locality was white. About 22% were African-American, and about 8 to 9% were Latinx. And looking at the denial of bonds, we recorded bond status, type of cases. And we saw that even though they only made up a small portion of the population, we saw that 55% of the denials going on were against African-American and Latinx folks. So it was disproportionately unfair, just looking at it. And we see it in our courts, we see it in our system, but to actually document it and see it happening. And then the other aspect we looked at was pretrial supervision. And we saw also that it was 45% of people of color were being referred to pretrial supervision. And that was one of our main things. We're looking at how mass supervision and mass detention has impacted us. And Alex has touched on it. There was the Prison Policy Initiative actually posted some stats on that. And he is correct. In this country, it might be close to 500,000 folks incarcerated in pretrial detention. And that's including ICE or ICE facilities. We don't even talk about juvenile facilities. So, we have this mass supervision and detention policies going on all across the country. And so that's what we looked at going in there. And so we consistently did this for the entire 2018 and part of 2019. We started in 2018, so we went to the courts up until the pandemic, basically. So we started in 2018 in January, and in 2019, and then for a year, we published quarterly reports. We even had a press conference at the court with our demands to correct the lack of representation, because we feel that every stage of the process, our community members and our leader members, it should have representation at every step of the process. And then in Chesterfield, there was no representation at arraignment hearings. So we saw that as a possible demand. No, it wasn't a possible, it was a demand that that state, because this is actually a legal representation falls under the courts. So we made a demand of the courts to correct this lack of representation. And Alex touched on it with now a lot of localities are implementing video arraignments. So you don't have to go in front of the judge to ask for bail, but you have video arraignments, and there's that disconnect because you don't have chance or an opportunity to meet with an attorney, even at a bail hearing. And that's one of the most crucial aspects of the whole process. We looked at denial of bonds. So we demanded that they look at this and implement some type of strategy or policies that would deflect or defer this happening. It's unfair, it's unjust. And then pretrial supervision was also in observing, a lot of folks and speaking with folks who were referred to pretrial. I even met with the pretrial director of that locality, and he thought it was unfair that folks were being driven to supervision. Basically, you're being put on supervision on bond. You're not even being convicted of a crime, but you're still under supervision and face penalties if you don't follow those guidelines, those standards. You could be rearrested. And so there's another step in. And we looked at this process is a driver to mass incarceration. And so that's why New Virginia Majority in our Court Watch program, we unveiled this. And we know it's so important for individuals to, community members to have that oversight. We need community members, and we mobilize community members because we're member-led and member-driven. And so when we've seen these outcomes and we were able to use these outcomes we looked at and used them to drive policy here in Virginia. We actually brought it before our legislators during our legislative session, and we were able to use that information and pushing for bills. And we had some court watch bills, bail reform bills that went through. And one of my colleague Kim, will speak on that about the risk assessment tools that magistrates use here in Virginia, which is another part of pretrial detention. The magistrates, and before I go on, I have to give a shout out, to Court Watch NOLA in Louisiana, in New Orleans. I consulted with them. They brought me in and exposed me to my Court Watch experience. So I was in New Orleans and with Court Watch NOLA, and their Court Watch initiative is massive. They look at every aspect of the court system from trials to pretrial. There that I learned more about the magistrate system and how impactful they can be. And so we are moving to even change that. And as I said, there's coming into a system, the magistrate has the power to release individuals even prior to even, that's because that is their initial entry into the system itself in pretrial. So the magistrates had a lot of power, and we are hopefully at some point want to go into that and look at magisterial systems and get the state and the Supreme Court to look at those policies and look at those risk assessment tools that are keeping people in jail, because these risk assessment tools and the algorithms that they use to create them have already been proven to be unfair, biased, and racist. So those are the things what we've been doing in Virginia with our Court Watch program. Unfortunately, because of the pandemic, with courts being shut down, and that's a whole nother story, we've had to suspend our program because we don't allow, if you're not there for actual court appearance or you're not subpoenaed, then they're not allowing the public to go in and witness and observe these programs, which is another issue we can bring up, because now you're looking at accessibility. We're talking about accessibility, transparency, and accountability, all those things. So that's what Virginia's Court Watch program has been doing for the last 2 years.
Okay, Thank you, Christopher. I think we have a couple of, maybe a question or two related to yours. So let me take a look at that. Well, one of the things that I was looking at was, is there differences in across the courts that you looked at, Christopher? Did you look at other courts? You mentioned Chesterfield. Did you look at some other court systems? Was there variances in court practices?
And that is a good question. Actually, we spawned our Court Watch program actually from the success we had. There was actually two other Court Watch programs that were launched in Virginia because of the success we had. Mm-hmm. But you're right, it varies from locality to locality. The principle shouldn't change. You know, what we demand is should be fair and equitable for all. That shouldn't change no matter what locality we're in. But there were differences in just the processes of those individual courts. They might have a different process, or as with folks, with people in power and people who are actually in these positions in implementing these policies and these processes, it's going to vary. It's going to change. There was one Court Watch in Williamsburg, Virginia, which started up with our help, and they found that they had a lot of challenges having access to the courts, being told, that they couldn't record they couldn't go in and observe, and it was a lot of barriers were placed. Even in Richmond, I've attended Richmond city courts, and I was told that I couldn't actually take notes in the court by the bailiff. So these are just the processes which can be addressed. But these are different. That was basically the only differences in the courts, is the processes and how these are implemented in the courts. But they still have to follow the same policies of arraignments, when a person has to be arraigned, and having access to legal representation. All those things are still valid. Denial of bond, which is a big, across the country, looking at bail programs. And I always thought that if we didn't get rid of bonds, there might be an excuse for them. If they can't give you a bond, that might be a reason for them to hold you. Because you have to look at the collateral consequences of getting rid of a whole bail system and just getting rid of a cash money bail system. But there has to be something put in place that is real equitable and really transformative. So we need progressive leaders who are going to push a lot of these things, a lot of these policies at the statewide level. But then at the same time, we need individuals to come in. But the variances, they weren't very noticeable. It's just knowing that the courts have to just look at things through a racial equity lens. They have to, based on the history of what's going on.
Well, thank you for that. Yeah, because there was a question about from Joanne Pina about were the denials of bonds for comparable charges different in different areas, or was it the same, similar, based on your observations?
Well, it varies from locality to locality. In Chesterfield County, you can see a pattern emerge, basically, that kept folks, especially folks who were challenged financially. They had what they call the recognizance bond, which is basically they put a dollar amount to it. So it's not really a recognizance. They just think of recognizance as being released on your own recognizance, basically sign your way out of jail. But in Chesterfield, there was a dollar amount attached to these recognizance bonds. That's something I wasn't too familiar with. A lot of localities don't implement it the same way. I say it falls a lot on the magistrates and the Supreme Court, the court system. They really, and we know a system that is broken and is part of this entire mass incarceration system. And so, yeah, we have to do a lot of work in getting our legislators and those in power to push, to change some of these policies and practices. But it's so ingrained in our system. So it's going to take all of us to really make this change. And thank God that pretrial justice has, been in the forefront with New Virginia Majority and a lot of organizations like Legal Aid Justice Center, who was very instrumental and taught me a lot. But when you're inside, like I said, we can talk about all these things, but I just want folks to know how horrible it is. It's a very horrible system. I've been incarcerated in 5 different states, and it never changes. It's like I just want to share some of the things. that you experience when you're in jail. I mean, it's deprivation. I mean, you know about deprivation, trauma. There's no really way of having access to resources, even legal resources. There's so much hopelessness. And when I was going, thought about, and I was fairly intelligent, and the whole time I'm going through this process, I'm thinking, my constitutional rights are being violated every day. All of our rights to having legal representation, to being safe from cruel and unusual punishment. Like I said, pretrial detention is 5 times as worse as prison sometimes. And I think I used to think that every American should spend one day in jail in some of the jails I've been. And then we think twice about how we treat those accused of crimes and being held. They think of it in a whole new light.
Thank you, Christopher. You brought up a couple good points that hopefully when the panel's all talking, we may come up with these, or we may have some questions. Particularly, I heard about attorney at first appearance and how that is so important and critical in a fair and just pretrial system, and a meaningful appearance where they have opportunity to interact and meet with their attorney and have that kind of conversation. So maybe we can have some time to talk about that. Also, I heard some conversation about the over supervision of individuals. And many people being placed under supervision and conditions such as GPS and other things that may not necessarily be necessary in many instances. And also good conversation and comments you made about the magistrate system and how those decisions are made. That's truly a kind of a low-hanging fruit area, particularly in Virginia, that has not been addressed much. And that maybe some critical decisions can be made at that point, because that is really the entry point, and that really decides where individuals end up in the system at the initial stage, and whether or not they even have to have that first appearance while in custody, because the magistrate makes that decision. Yeah. So we'll pivot over to Kim, and got some conversation that we'd like to have with Kim. So Kim's been working with the Legal Aid and Justice Center, the Civil Rights and Racial Justice Program. And so they have been also doing lots of things around, mostly with many things around legislation, watching what's going on in Virginia. Her group has worked with legislation that has not passed yet. We're having the defense attorney appear at first appearance, but they did some successful work on Virginia's rebuttable presumption laws in the last General Assembly session. So, Kim, would you like to talk to us a little bit about some of the work you're doing there?
Sure. Thanks, Steve. And I think similar to how Alex started, I wanted to pull back just a tiny bit and say, in the intro, you mentioned, I work for a legal aid organization. And I think some people are from, we provide civil legal services. I think some folks are like, why are you talking about pretrial detention? I actually started, as you mentioned in the bio, as a housing attorney. I did eviction defense. And I think it's really important for folks to know, we, as an anti-poverty organization, we can't do effective anti-poverty work without talking about the criminal legal system targeting people that are in poverty and exacerbating people's poverty. And we also really believe, and we're titled the Civil Rights and Racial Justice Program, is that we can't be an anti-poverty organization without addressing racism in the US. And the criminal legal system is one of the most potent manifestations of that. So that's why I'm here as a legal aid attorney talking to you about these issues. And, my program is the youngest at our organization. We're about 3 years old. And when we started the program, we really knew that we had to address pretrial, because I had seen pretrial detention cause people to lose their housing. I had seen it cause people to lose their jobs, to cause custody issues for them. I just really want to echo everything Alec and Christopher said about making this a human issue, first and foremost. And so I think the issues that have been raised already by Alec and Christopher, I think tie perfectly with the pieces of legislation that a group called the Pretrial Justice Coalition, that actually both New Virginia Majority and Civil Rights Corps have been involved in with LAJC and other organizations over the last couple years. We had worked with legislators to introduce 3 pieces of legislation in the regular General Assembly session in early 2020. And I'm going to tell you a bit about each of them because I actually think that they provide some more state-specific context for some of the issues that have already been raised. I'm actually going to go out of the order that I originally planned to go because I'd like to talk to you first about pretrial data transparency in Virginia. And I know that is, it doesn't immediately sound like the sexiest issue to address, but the reason I think it's so important is what Alec mentioned about if we address cash bail or what's called secured bond in Virginia without addressing the root evil, which is detention. The root evil is that assessing that unattainable money bail means that people will be held pretrial. If we don't go to that route, they're just going to find another route to get there, right? And what we actually found, we did our own Court Watch program, which is a much smaller version than the incredible community-driven base building that Christopher has done. But we did kind of a more diagnostic court watching. I sat in magistrate hearings after fighting with magistrates about whether the public should have access to those hearings. We trained observers to go into general district court. And one of the first things that as someone who had not done direct criminal representation in Virginia, I was really struck by was the prevalence of outright detention, people being held without bail. And in our own data set, when I started to run the numbers, it was really alarming. I think our numbers were approaching 40% of the people that we saw in magistrate and what are called advisements or arraignments, people that are in custody, their first appearance in court, were people who had just been outright detained. They didn't have a secured bond, they couldn't pay. It wasn't some unattainable condition. It was just that either the magistrate or the judge had said that that person is going to be held pretrial. And around the same time that we were doing this, the Virginia State Crime Commission had started what they call their pretrial data project. And I'm happy to go into more detail if folks are interested, but long story short, they looked at what they called the October 2017 cohort. They looked at everyone who came through our criminal legal system in October 2017 and tracked them to December 31st, 2018, and tried to create a picture of what their pretrial, what had happened when they moved through the pretrial system in Virginia. The reason this is necessary is right now, and I actually in the Q&A saw someone ask this already, we have a terrible system of data collection for this. There are about 9 different state and local databases that hold information about pretrial systems. Several essential points aren't held anywhere. So it took them a ton of labor to gather all of this data, put it together in a way that they could analyze. And we saw the first preliminary information on that. They gave a public presentation on November 8th, 2018. And I was blown away because I had really thought that, I'd seen this in our observations, but to see that this was across the state, they looked at all the people coming through the system in October 2017. Again, no reason to think this is an unusual month. And they found that the most common outcome, and when I say the most common outcome, I mean even more common than giving a summons, right? So anyone who has contact with the criminal legal system that is going to have charges against them, the most common outcome was being held without bail. 26% of people held without bail. And I just want to drill this in, that is, keep in mind, 60% of the people that came through the system in that month, misdemeanor charges. On top of that, 15% had a probation, failure to appear, or contempt of court as their only charge. So in that pool, 26% of people were held without bond. If you take out the 23% that were given a summons, that means that the people that actually were full custodial arrest taken before a magistrate, we're talking high 30%. I think it works out to 37 or 38% of people held without bail. That should alarm people. You will hear in Virginia that we don't have a cash bail problem. We don't have unattainable cash bail. And I'm here to tell you that the reason we should care about cash bail is that people are put in cages before, haven't been found guilty of any crime. And that is happening another way in Virginia. We are holding people without bail. And I think to also really, I want to lift up this as an issue of race in the U.S. And both, Christopher and Alec have, mentioned that. And, I would be remiss to remind folks that the 23,000 people in that study cohort of October 2017, 40% of them were Black. And in Virginia, there's about 20% of folks that our population that are Black. So that's double the representation. So when we talk about this evil pretrial detention, that is falling on disproportionately on Black and brown people in Virginia. So that was my long wind up to say, one of the things that we realized in multiple ways was that, this data has got to be public. We need to create a system of publicly accessible data that shows what's going on in our criminal legal system in the pretrial context, because Christopher is out there doing that hard work every single day with his community members, but they're not in every jurisdiction across Virginia. And we need that info, because our system also looks very different, as Christopher said, in all these different spaces. We need a system to collect that data. And this kind of one-off, 1 month snapshot won't do it, right? Because if we're serious about changing the system and decreasing our pretrial detention numbers in Virginia, we need a mechanism to actually see if what we're trying to do is working. So we had introduced legislation to require collection on pretrial data, and I'm happy if folks are interested to talk about exactly what pieces of information that we would have required to be captured. To go run through really quickly, an actual written reason for bail denial, the most serious charge of the person detained, whether people were homeless, publicly accessible race, age, gender, demographic information on folks. So that bill did not pass the full General Assembly, but there was one thing that actually made it into the budget amendment that took the language of our bill and went into the budget and actually required the Department of Criminal Justice Services to give a report on what it would cost to create a pilot program for data collection in the handful of jurisdictions in Virginia. So basically what we heard repeatedly was like, we can't do this, it's cost prohibitive. So we were able to get something in the budget that required the Department of Criminal Justice Services to actually say, like, what would this really cost? Like, what would this really cost to do in just a few jurisdictions to see if we can make this work? And again, this is not to have data for data's sake, but really, one, to shine a light on what's happening in these systems, and two, to give us the tools to make sure when we are engaged in reform efforts, we're addressing the root evil, right? We're not doing what Alec talked about, that, we minimize secured bond, and then the system reconstitutes itself and is locking up Black and brown people pretrial using a different mechanism. So that is one piece. And then very quickly, because I want to make sure we have plenty of time for our discussion, the two other pieces of legislation, one of which Christopher addressed, beautifully already, what we called our meaningful first appearance legislation. So your very first, if you are experiencing full custodial arrest, the very first bail determination, and Steve mentioned this as well, is before a magistrate. There are not lawyers there. Almost no one is represented in those magistrate hearings. They're very brief. I sat and observed them. I would say incredibly unusual for them to be more than 10 minutes. That is certainly a problem. We actually, to try to go to even lower hanging fruit, said, let's go to the first court appearance. If someone is held pretrial, their very first court appearance, what is called sometimes an advisement, sometimes an arraignment, they're advised of their right to attorney, of the conditions of their bail, of the charges against them. It is wildly inconsistent across Virginia whether the judge at that first hearing will address bail conditions at all. Sometimes they will not. I've been in rural jurisdictions observing where even if someone says through video conference, like, I have to be at work, I have, my child, I need to, and the judge will say, your lawyer will be out to see you, and they'll file a bond motion if it's appropriate. They will refuse to address it. Other jurisdictions, the judges will review, but they won't engage. There won't be a defense attorney there representing the person because they haven't been appointed yet. So the judge will do it and may change the magistrate's determination, but that person won't have the benefit of counsel. So I put in the Q&A pod for someone that was actually House Bill 820. Last session we put in by Delegate Don Scott to make that first appearance before court meaningful for people. And it would do, very briefly, it would guarantee that everyone in custody has a lawyer at their first court appearance, make sure that lawyer has the information about their client and the bail decision that's already been made that's necessary for them to advocate. They're able to meet with their client and consult before the argument, and it requires that the court hear arguments from defense counsel or the prosecutor regarding bail at that first hearing. The last bill, and if people are interested, happy to talk in more detail. It's kind of a more in the weeds thing, but we have over 40 presumptions against bail in Virginia, which means just by virtue of you being alleged to have committed that offense, it flips the presumption of innocence on its head and says, no, we're going to presume that there's no way that you can be safely released. There's no way that you can be released, and we can, be sure that you won't be a danger to yourself or the public, and that you'll come back to court. So we had put in legislation to just strike all those presumptions. And so folks know these started proliferating in 1996. These are absolutely a legacy of the racist war on drugs, of a tough on crime era. They have no correlation to any kind of data about people who are alleged to have committed those offenses. They are just, they are this horrid manifestation of tough on crime rhetoric. So we tried to strike those. Unfortunately, we were not able to successfully pass that legislation as drafted. It did pass in a pretty significantly amended form, though, that show you how absurd the system is. It actually, the law prior to this bill was that the magistrate couldn't even determine that the presumption had been rebutted. So you would go before a magistrate, be charged with one of these things, and you could attempt, without a lawyer, again, all the problems with that, of you trying to articulate why that presumption shouldn't take the day, right? That you can say, no, I will come to court, I'm not a risk. The magistrate wouldn't even be able to decide that you had successfully done that. They would have to call the Commonwealth attorney and ask the Commonwealth attorney for their permission. And I will tell you, and sitting in a lot of magistrate hearings late into the evening, early hours of the morning, I never saw a magistrate call a Commonwealth attorney, not once. So we did successfully pass a bill that allowed the magistrate to determine that those presumptions have been rebutted. It's a really, really small slice of this problem. These presumptions need to be done away with. Judges have, they need to be done away with. I'll just say that. I don't want to get on my soapbox because I think I've talked for too long. But those are the three big pieces of legislation where absolutely the Pretrial Justice Coalition will be back in the General Assembly, the full session in 2021. And if anyone is interested in getting involved in the coalition and helping us do this really needed policy work, please you can put your contact information in the Q&A, and I'm happy to follow up with you.
Thank you, Kim. Great conversation, and your organization has been doing some fantastic work and is well engaged. The changes that happen in criminal justice systems really happen at that grassroots level. That's why it's been so good to have the panel that's here today, because they've been doing the work on the ground. I just want to note that we got 204 participants, so I really appreciate everybody sticking with us. This has been a really engaging conversation. We have quite a few questions that have been coming up, so it would be wonderful if the panel could join us. You turn your cameras on if you'd like so we can see you. One of the questions that we had was about what kind of legislation, and you have touched on that, Kim, for what your organization is doing. I was wondering if the other panel members had anything to add to that question. Any comments or thoughts on that?
Yes, I'd like to share. I think I shared in the text in the chat box by mistake that we were advocating for like changes in some of the policies. And one of the bills we had got passed last year was removing the presumption from magistrates that would force them to send individuals in front of a pretrial judge to advocate for their bail. So that was removed from the magistrate system. So they won't be able to use that anymore to deny folks bond upon their arrest, upon their reentry into the system. Now, the fact that now that we had the bill passed, and I think Kim will attest to that, we have to get the magistrate system, which lies within the courts, to actually start implementing some training and getting folks acclimated to that type of process. Even though it's on the books, we still have to look at implementation of the law. So we have to stay vigilant in that. Thank you.
Anybody else have anything to add on that point? Alex, a question came for you. If the Virginia legislature eliminated money bail and the rebuttable presumption statutes, what overall impacts do you think that would have for Virginia's pretrial systems? And I think I know where you might go with this since we had that culture conversation, but please tell us.
Well, I think that one thing that you have to understand is that as long as there's this pressure on the court system through so many arrests, there's going to be enormous pressure to find shortcuts to process those cases. Everybody understands that we can't possibly have this many jury trials. And so I'm oversimplifying a little bit here, but basically, the system is going to look for ways of detaining those people. So in our work, we certainly oppose presumptions because presumptions are actually unconstitutional. The presumptions that were put into the federal system were only saved by the federal courts as a matter of their constitutionality by holding that they aren't actually presumptions. So the Virginia presumptions are unconstitutional to the extent that they say that someone is presumed to be detained based on a certain offense or certain priors. Right. But I think that the more critical point is we need to do what New York State just did. Governor Cuomo's legislation removed the discretion of prosecutors and judges to even detain in the vast majority of cases. So unless you're charged with a very narrow, so this is the law in California as well, unless you're charged with a very narrow set of offenses that involve physical harm to someone else or threatened physical harm to someone else, the court can't even consider detaining you. And so that bail reform is rolled back a little bit by a sort of a prosecutor and police union backlash in New York, but it still has most arrestees are ineligible for either cash bail, secured bail, or pretrial detention. That's the kind of thing that we need to move to legislatively, not just eliminating the presumptions, but removing the discretion of the judges to do bad things, to do illegal things, and to detain people. And so when we talk about reforms that actually shrink the size of the system, we're talking about reforms that eliminate things like detention as even a possibility in certain categories of cases. And those are the kinds of categorical reforms that we are advocating for around the country.
And if I could jump in, I think that's a really good point, Alec. And one of the things that we actually in our coalition struggled with is I always use the catchphrase of like detention eligibility net. That's just the like easiest way I've heard people say of like succinctly like who could actually even be potentially held pretrial, whether it's through being held without bail, or an unaffordable secured bond. But when our coalition discussed this, one of the things that and there was legislation that was introduced that was not coalition legislation to require a citation, like a cite and release, where there would be certain offenses that folks could not even experience a full custodial arrest. And the coalition really couldn't craft legislation because the line drawing around offense category really divided the members of the coalition. But I really appreciate what you just said of like it's a huge issue that it's even possible under this magisterial and judicial discretion to hold people for the types of offenses. Like one of the things that just really stuck in my mind that I will never forget was a hearing I sat through where a magistrate held someone who had an intellectual disability, lived in a residential home, and was alleged to have assaulted a staff member. And the reason that magistrate articulated out loud was that I'm going to hold him because if we released him, he wouldn't have anywhere to go. And like that, and this is like a simple assault charge, assault and battery. It blew my mind. So I really appreciate the point that you just made. And I hope that we can continue to do the work to build a broad base to do exactly what you're describing, of even taking that off the table. Because I want people to know that people are being held for, it is not unusual for people to be held with misdemeanors. I mean, that data set I mentioned in October, that is happening every day. And I'm sure Christopher can tell you that too from his court watch.
Yes. Thank you, Alec, because that is one of the first things we noticed. Like our biggest challenge would be the judges. They have judges on the bench, retired judges. And actually, I've seen it. I've been in court, and I had to be careful because, I relive trauma every time I go into courts because I'm experiencing these injustices. And for one example, in court one day, we had about a dozen defendants. All of them were denied bond except a middle-aged white guy who actually had killed somebody in a car accident and admitted he was at fault. But the judge was like, "Well, you have a job. I'll give you a bond." But everybody else was denied a bond, and it was so unfair. So those things. So when you talk about the judicial discretion, and trying to get our judges on board. And that's a real big challenge. Taking that discretion out of their hands, like you say, it would be a great move. Because I see it every day in the courts. The judges are human too, and they have their faults and their biases. So we need to take that out of their hands. Thank you.
Great, yeah, and then we have a number of questions are still here. I just want to let participants know that we probably won't get to all of your questions today, but we'll do the best we can to answer them, even if it's after the event, and possibly post those on our website or send those out to the participant list. Let's see, a question about data from Wyatt Brown. What data and effects are you seeing from states and localities that have eliminated modified money bail systems? Anybody have any information? Alec, maybe you may have some information on that.
Is the question is what kind of information we have? I'm trying to find it in the scrolling. It's about whether we have good enough data.
Yeah, what data and effects are you seeing in the states that have eliminated or modified their money bail systems? Because a number of states have changed.
So it's not a Virginia specific question. Okay,
No.
So I mean, I think one of the scandals of this punishment bureaucracy is that we haven't really collected very good data about almost anything the system does. And so California, for example, has virtually no statewide data on what's happening across the state pretrial. Nobody can tell you what percentage of people are detained, what percentage of people are released, what case outcomes are associated with that at all. And that's the largest criminal punishment system in the country. Similarly, it's too early to tell in most of the places that where we have some data are New Jersey and New York. In New Jersey, they dramatically reduced pretrial detention when they eliminated money bail. And in New York, the early numbers are astonishing. It's something like, jail populations down like 40 or 50%, depending on how you count, because of the new bail reform. So in all of these places, there has not been a single place where there's been any link to increased criminal activity or flight from prosecution or anything like that. We've also just released a very robust data report from Harris County, Texas, which is the Houston metro area, which is itself bigger than 25 states. So it's not a small jurisdiction. It's the third largest criminal punishment jurisdiction in the country. And the results of the reformed money bail system there have been absolutely incredible. The report is being monitored by a former UVA professor who's now running an institute at Duke University named Brandon Garrett. And Professor Garrett's monitor team for the federal court just released their first report showing that the pretrial detention is way down in misdemeanor cases, almost non-existent now. No effect on new criminal activity or non-appearance, and they virtually eliminated the racial disparities in pretrial detention and misdemeanor cases there. So it's very encouraging. The initial report in Houston, about 17 or 18,000 people are going to get out of jail now just in Houston alone as a result of that settlement every single year. And so I think it's really important to understand why, though, the system hasn't collected data until we've sued them or like the system has made no attempt to measure whether the pretrial system was leading to public safety or court appearance because it never actually cared about that. That's not why we created the money bail system. Those are the sort of propagandized, like ostensible reasons offered by the system to justify what it's actually doing for other reasons. And I think it's very important to understand why rampant pretrial detention, unlike what we've seen in any other country in the modern history of the world, why has it happened? And it's because of mass incarceration. It's because the rest of the system couldn't possibly handle that many people without coercing them to plead guilty. That's why it's happening. In addition to the financial interests that are involved in this country that aren't involved in other places. So I think it's too early to tell in most places. And just if we're being candid, almost with the exception of New York, I haven't actually seen a state do bail reform in a way that could in any way be described as positive. Even the New Jersey reforms are very scary because while they've seen dramatic reductions in pretrial detention so far, the New Jersey reforms actually have an unlimited detention net, to use Kim's term. When Chris Christie passed that bill, they eliminated money bail essentially, but they amended the New Jersey Constitution to allow for people to be detained in any case at all. And that is very scary going forward.
Great. Thank you, Alex. There's a great question that I think we should ask because there's been some changes with Commonwealth attorneys in Virginia, and we have a number of progressive prosecuting attorneys that have been running for office and have been winning in many jurisdictions. Abdel Hamed has a question about, there is a wave of progressive Commonwealth attorneys running for office. What role do you see the Commonwealth attorneys, which in Virginia is the prosecutor for those from other states, given their discretion, what do you see their role in playing in addressing the pretrial detention until reforms are codified?
Yes, and I like to answer that initially. I actually, in our court watch experience, I actually formed an alliance with the Commonwealth Attorney of Chesterfield County at the time. And he was very accessible, very supportive of our court watch program. He actually implemented some policies within his office, asking his CAs, his attorneys to not pursue money bail. And even in Virginia, the same thing, the Commonwealth Attorney in Virginia, who I'm friends with, she also implemented a policy where her attorneys would not seek money bail for like marijuana possession, certain misdemeanors. So they have basically what they call the no cash bail policy there. So CAs, progressive CAs can really, they're like our allies in this fight, and they can actually implement policies. They can't make law, but they can implement policies within their offices and their localities, which can limit the amount of bonds and referrals to pretrial. The Commonwealth Attorney I was friends with in Chesterfield, he admitted that fact that too many people were being referred to pretrial services, because for some folks that is a challenge. And it's unnecessary for them to be penalized again before they even go to court. And so they are very instrumental. And there was another question about public defenders I wanted to address. And that basically is like our allies within the system. We have many allies. And I feel for public defenders in the system. I actually advocated for them to have pay increases and get more funding, because of the playing field between the Commonwealth Attorney's Office, prosecutors, and those public defenders is uneven. They have all these resources, the state, but public defenders are struggling. Just one example, in 2017, the Richmond City Public Defender's Office looked at over 70,000 cases. They only had 27 attorneys on staff. That was in 2017, 2018. Forgive me if I had the year wrong, but that is an actual fact. So they're overburdened, underworked. So we have allies in this fight, and especially Commonwealth attorneys. Unfortunately, the gentleman who was our ally, he was defeated in the following election. So that goes back into voter registration empowerment. But I like to add that our CAs can be very impactful in limiting the amount of pretrial detention and seeking for folks to be incarcerated. Thank you.
Yeah, I did want to add one thing to that. I absolutely agree with Christopher that Commonwealth attorneys have a role, obviously, in the discussion we're having right now. Though I would caution people to, I think we've seen some posturing by Commonwealth attorneys that make some questionable. So, for example, in Richmond, our prior Commonwealth attorney announced that he would direct his Commonwealth attorneys, deputy Commonwealth attorneys, to no longer request secured bonds, which is Virginia's cash bail. And basically he styled this as like, this is the end of secured bonds in Richmond, like cash bail, we're eradicating cash bail in Richmond. There are a number of problems, one of which was that the deputy Commonwealth attorneys were still requesting secured bonds. There is a statutory requirement in the Virginia Code right now to request secured bonds to be ordered in certain circumstances, which, and I think my point being that, and also the magistrate, right? The Commonwealth attorney is not at the magistrate hearing. Also, the judge can make a decision whether or not the prosecutor the Commonwealth Attorney makes a recommendation to impose a secured bond. And when that, let's say under that statutory provision that requires it in certain circumstances, they can pick an amount, whether the Commonwealth Attorney recommends one or not. So I think like when we are asking Commonwealth attorneys to show up authentically to this conversation, if they are, and I believe we have some Commonwealth attorneys who are deeply committed to transforming the criminal legal system and ran on that platform, that it means more than staking out kind of some of those talking points and being like, I don't recommend cash bail. Like that's not adequate. That will not fix the system in Virginia. And we need to push those Commonwealth attorneys to do more and to be, to be honest about all of the ways the system needs to change. And some of those things they don't have direct power over, but they certainly have immense influence. And I think the question actually mentioned the new group of Commonwealth attorneys that has formed as kind of a counterpoint to VACA, the Virginia Association of Commonwealth Attorneys, that has been a major force in our legislature, that has been a counterpoint to many of these reforms and has pushed against them. So I think we need to ask our Commonwealth attorneys to show up in the myriad of ways that they can flex their political influence.
I have a few thoughts about this issue too. I think it's not just particular to Virginia. All over the country, there's a wave of so-called progressive prosecutors. And I think we have to be very careful about this. A lot of the power so the movement is predicated on the notion of prosecutors being, one of the most powerful figures in the criminal punishment system. I think that's certainly been true over the rise of mass incarceration, but I think with one caveat. They've been so powerful because they've, by and large, used their power to target poor people and people of color. They've used their power in very harsh ways that are consistent with the goals of the punishment bureaucracy generally. If you started to have prosecutors who do the opposite, let's say, refuse to prosecute poor people for drug offenses and only prosecute police officers or only prosecute wealthy people, or if you had a prosecutor, I was doing the podcast for one of the progressive prosecutors the other day, Chesa Boudin in San Francisco. I made the point to him that everyone thinks you're so powerful, but tomorrow, if you said, we have a homelessness crisis in San Francisco, we also have a problem with all these tech billionaires hoarding wealth. So I'm going to announce that I'm not going to prosecute a single person who doesn't have a home if they go into the spare bedroom of someone who has extra homes, or someone who has extra bedrooms in their home. If you just announce that prosecutorial priority, you'd be the least powerful person in San Francisco. You'd be voted out of office tomorrow if you started saying, I'm not going to enforce trespassing laws, right? So we have to understand why prosecutors have been so powerful. And it's precisely because they've been using their power in ways the system wants them to use their power. And so when you start having prosecutors around the country who've said, I'm going to stop requesting cash bail, what do you see? You see police officers trying to bypass those prosecutors. You see judges just ignoring them and setting cash bail anyway. You see the system reacting. You see some of them being facing recall campaigns and things like that. So just wanted that caveat. I've written a lot about this issue. If you're interested in hearing more about at least what I think about the progressive prosecutor stuff, I have a whole section on this in the book that I wrote. I'll just put it in the chat box for anyone who's interested in reading more.
This is a really brief tag onto that. That's absolutely happening in Virginia. Check out the coverage in Norfolk of what happened when the Commonwealth Attorney recognized racial disparities in police bringing misdemeanor drug possession charges and tried to null pros them, tried to say, we're not going to move forward with these. And the judges wouldn't allow the Commonwealth attorneys to do that. They basically said that they would hear the cases and move forward with them whether or not the Commonwealth Attorney's Office participated. They wouldn't allow them to null pros. So I think Alec's point is absolutely one that we see in Virginia as well.
Well, great. We do still have a number of questions, but we're not going to have time to get to all of them, but we will do our best to answer questions after the event to the extent that the panelists can help us with that. But I did want to move in for an opportunity because we have maybe about 6 minutes left for each panel member to do some closing comments for us. And in your closing comments, I would appreciate if you would talk a little bit more about what you think Virginia can do right away to move to a more fair and equitable pretrial justice system, and how can people that are watching today on the webinar be a part of that? We have a lot of, I think we have a lot of policymakers on the webinar today. We have practitioners, we have people across the country, but we do have a number of people here in Virginia. And since we are talking about trying to move our state forward, curious to hear your thoughts on that. I don't care who wants to go first. You all just jump in, please.
Well, I can start. I mean, we only have 5 minutes, so I don't know how deep a dive I'm going to do. I think it's incredibly important that we provide people access to zealous criminal defense as early as possible, partially because of what Alec was discussing earlier about the need for these hearings to be, more than, perfunctory 5-minute hearings. These need to be robust. This needs robust due process because this is someone's life. This is someone's life. You're putting someone in a cage after these hearings. And I will fully acknowledge that our meaningful first appearance legislation, that's a one step. I think it's, if someone is in court and having they should have absolutely their conditions of confinement reviewed, and they should have the benefit of informed counsel during that hearing. But also we need to address the magistrate hearings. They are absolutely, it is shocking to see the dearth of process that is given someone before they are held in those hearings. So I think that is a huge piece. And I also deeply believe that we need the data about what's happening in the system, both for people to understand the scope of the problems in our pretrial system, and to make sure that we don't have the kind of reform that just allows the system to reconstitute. So those are two things that we have been pushing for. We're going to keep pushing for. And again, if there are folks who are in Virginia that are listening to this and want to get involved, please put your contact information in the Q&A, and I would love to connect you to our coalition in the work.
Thank you, Kim. I guess I'll step in. For Virginia, what needs to do next for more fair and equitable Virginia? We have to have the courts. We have to force our courts to adopt policies and practices to correct a lot of these things that are going on in our government. We have to have magistrates, prosecutors, and the courts. We have to look at, they must look at punishment, crime and punishment through a racial equity lens. That has to be, I think that needs to be in there. Then the other part is that citizens, residents, we have to mobilize, and we have to consistently demand transparency and oversight and equity. So I think as an organizer, speaking as an organizer, we have to stay involved with civic engagement. We need civilian oversight and things like court watch initiatives. So I would urge folks to really stay involved if they have the capacity to help move a lot of these things that are going on. New Virginia Majority is just one organization, the Legal Aid Justice Center, and there are several organizations and entities out there and folks who are looking at transforming our criminal justice system. I just want people to don't forget about the school to prison pipeline, which needs to be severed. We need to use resources for alternative ways of incarcerating folks, especially our children, and also looking at immigrant justice for undocumented, at these ICE agencies and other agencies practicing mass detention and mass surveillance. So we have to challenge our legislators and challenge ourselves also to do whatever we can do as individuals to help change this narrative around crime and punishment. And dare I say, we have to look at it a more holistic view of how we view public safety and policing. And so that's what my thing. As an organizer, I say it's on individuals. It's on us as together we do it better. So I urge folks who are on this call and have those conversations about changing the narrative and basically pushing our legislators and making those who are empowered look at what's going on and forcing them to make a change. Thank you.
Great, thank you. Alec, you get the last word.
I would just say, no matter what your role is in the system, don't let yourself become one of those people who is desensitized to what the system is doing. Always remember that you should be shocked by things that are cruel and painful and traumatizing and senseless. And the system is full of those things. So never be one of those people that allows yourself to become desensitized to things that should shock you to the core. And then we have to think, boldly. I mean, we have a system that is bureaucracy that is 5 times larger than it was for the first 200 years of this country's history, 5 to 10 times larger than every other comparable country in the world. We need big, bold changes to the system. We should never have a system that says we're putting someone in a cage where they're likely to be sexually assaulted and get an infectious disease because we don't know what else to do with them, like Kim was saying. because we don't have housing for that person. We don't have medical care. We don't have health care and mental health treatment. So the first step, though, is divesting from this bureaucracy. So if there are legislators and policymakers on the call, our staff has an amazing team that works with folks on reforms to bail and to other policies that actually reduce the detention net and that decrease the size of the system, and that can then think about creative ways of taking those savings and investing them back in the community. And that's, I think, that what we need to be thinking about now is how do we divest from punishment and pain and invest in the things that help people flourish.
Great. Great. Thank you, Alex. And I just want to say heartfelt thanks on behalf of Virginia Community Criminal Justice Association to all our panelists today. That was a great conversation. We really hope that this helps get the change going that needs to happen in our state and across the nation. And it's really a positive conversation. So I just want to thank Alex, Kim, and Christopher for taking time out of your schedule to be here. I just want to remind folks that unanswered questions we'll try to get to afterwards and be in touch with you all on those. This session has been recorded and will be placed on our association's YouTube channel at www.vccja.org, and I'll also try to email it out to all the participants who stayed on the call. I want to thank the Miller Center at the University of Virginia for helping us with this event. We could not have done it without them, and thank you. I also want to remind all the participants that we do have a second part. This is the beginning of a conversation, and it's going to be on October 19th at 11 o'clock. Registration will be going out in a couple of days. This webinar will take a slightly different approach and look at a policy lens on what's going nationally in pretrial justice and specific work that's being done in some Virginia localities as well. It will feature Mark Levin from Right on Crime, Monica Reed from the National Association of Criminal Defense Lawyers, Brian Kennedy with the Public Defender's Office in Fairfax, Virginia, and Tim Martin, who is Commonwealth Attorney in Augusta County, Virginia. And that session will be moderated by Nick Sainer, who is the president of the National Association of Pretrial Services Agency. So again, thank you all for joining us and taking time to listen to this important topic. Thank you, our panel, and everyone have a great afternoon.